Welcome everybody. My name's John Broome. I'm Deputy Chair of the Contracts and Procurement SIG. Before we start the webinar with Sarah, just a quick introduction to the SIG. The SIG has this belief that virtually all project managers should have a working knowledge of basic contract law and procurement in order to be effective, because most projects involve to varying degrees buying in stuff, whether that's a few bits of kit, some people, or whether you're actually contracting out large parts of the project as a project. And what we do is we do seminars, webinars, which go from covering the basics, which are the most popular ones, to the leading edge stuff, pushing the boundaries out. This is very much at the basics level, hence the title Basic Contract Law for Project Managers. For those who listened to the first Basic Contract Law, the feedback was extremely positive and it met my expectations of what Sarah would deliver, which was basically a very practical seminar in plain English. And that fits with what I knew of Sarah and Sarah's background. Without further ado, I will hand over to Sarah.
Thank you very much, John. Welcome to this second webinar, series of 3. I'm thrilled to be joining APM and its members again. This time we're going to be talking about building a contract. So the topics we're going to cover today are these. We're going to look at the components of a contract, how you structure it and how it's made up. We're going to look at boilerplate clauses and negotiated clauses, and I'll explain the difference between those two at the relevant time. We're also going to talk about how building a contract relates and impacts and is impacted by risk allocation. I want to talk a little bit about who should be involved when negotiating a contract, when discussing what the components of a contract should be and how they should be shaped. And then finally, a little bit on project managing a contract's development. So that's what we're going to cover in the next 50 minutes to an hour. A brief recap on the background to the series itself. My business and my core belief is centered on the reality of using law in practice. I am a lawyer by background, but I try to make law very real for my clients. I want to apply it to your project. I want to help you as your project develops and to enable the project to deliver the outputs which it has set out to achieve. In my mind, and I'm passionate about this, project managers are central to the smooth running of a project, and you have a number of things which you have to juggle. You need to be multi-skilled in a number of areas. That doesn't mean that you need to be an expert or a specialist in those areas, including in law, but you do need to have enough knowledge about a number of different areas to be able to fulfill your own role well. Parties to a project, of course, depend upon you as project manager to administer and to manage the contract, and also to give direction to the parties at certain points in the contract. So therefore, the question is asked to me, why should project managers learn about contracts? Well, including all of the above, there are two main risks. That is that the project is put at risk, or the project doesn't deliver as well as it should do. It comes in under par. And more importantly, in many ways, for you as individual project managers and the organizations that you work for, there's an element of those two things being at risk as well. So I'm passionate about project managers learning about contracts, and I'm thrilled that we've been able to organize this series of 3 webinars. A little cautionary footnote, do enjoy and get to know the basics of contract law and how contracts work, but just as important as knowing what you do know is knowing what you don't know, and do be aware that you will have limitations. I'm not seeking to turn any of you into lawyers overnight, and do seek advice from a friendly lawyer or someone who is very experienced in contracts. Okay, let's have a quick look at the background to this webinar. So in webinar 1, for those of you who attended that or who have listened to it since, we looked at the foundations of a contract and all those essential features that a contract needs in order to make it a contract and to make it legally binding. In this webinar 2, we're going to evolve that concept, and we're going to look at the terms of the contract itself. And those really arise in two situations. One is where you're drafting a contract yourself or getting help to draft a contract. And the other is when you receive a contract. You are reviewing a proposed contract, perhaps from your client or perhaps from your supplier. There are going to be terms which you're going to want to include, and those of you who've attended and listened to webinar 1 will know about the risk of implied terms. There will also be certain terms in those contract situations which are more risky to you, to your client, but nonetheless are commercially acceptable. And at that point, it's how you manage the risk which becomes the important thing. We're going to delve deep into that this afternoon. And there will also be certain terms which are, in fact, unacceptable to the organisation as a matter of policy. Okay, so we're talking about corporate norms there. And those may well be so unacceptable that you have to walk away from the proposed deal. So that's the scenario which I want to set out as the foundation of this webinar too. So let's look at the components of a contract. This is how a contract will be set out, and you may well be familiar with this as a structure. This is the very typical way in which contracts are set out. So right at the top, you'll have the date, and it will say something like this contract or this deed is made on, and then there'll be a space. We're going to look at each of these in turn, by the way, in the next few slides, but just to set out the structure in general at this point. You'll then have the parties, so that it will say something like between party 1 and party 2. You then have a section called the recitals. Sometimes these days it's headed up as background because that is the plain English way of describing the archaic legal term recitals. But what we're doing is we're reciting, we're explaining, describing the background to the contract and why the parties have come together to make the contract together. We need to have a consideration term, and again, reference to webinar 1 here as to the importance and necessity of consideration to making a contract. In many cases, that will be the value of the works which are being provided or the services which are being performed. You can have contracts at nil value, such as in a framework situation or collateral warranties, where no money is actually being handed over, in which case you need to use the phrase which is on your screen, in consideration of £1. Sometimes you see £10, but more often these days it's £1, I have to say, being paid by A to B. Okay, so if you have a nil value contract, you must nonetheless have a consideration clause to show that consideration is being given by one party to the other. Terms. Now, a couple of you raised questions with me separately and also through the forum as to terms. So I'm going to look very closely shortly at different types of terms, but listed there on the screen are all the different types of terms that you can come across, and each of them has a different legal effect and different legal consequences if it's not complied with or it's breached. So this is a really important part of contract law, and it does take quite a lot of learning, but I will flag up to you shortly a few of the key things to look out for. And then finally, the last component of a contract is going to be the signature or execution blocks. This is your signature by any authorized person of the organization entering into the contract. And if it's a contract under hand, a 6-year contract, it will be a signature block. And if it's a longer, a 12-year deed, then it will be a full execution block. So that's the structure of how the contract looks. I expect that looks familiar to many of you. That is the usual way in which contracts are set out. Right, so the date is the last bit to be completed. Okay, it usually triggers performance by the parties. So you'll often see that written in pencil saying do not date or something like that. So don't touch that bit until all the rest of the contract has been completed. The parties, things to look out for. You need to ensure you've got the right name of the parties. It sounds pretty obvious, but it's amazing how difficult it can be to get that right, particularly in multi-layered or joint venture or SPV type arrangements where you've got a multi-tiered, multi-layered vehicles which are delivering big projects. Make sure you get the right name and the correct registered office for the party which is entering into this particular contract. Recitals, as I said, they set out a description. So what you need here is a full description of the story, okay, which leads right up to this moment. At the time that the parties are entering into contract, this is why we're doing all of this, okay? Do avoid, however, anything which is commercially sensitive or any details which are not general descriptions of the project. Consideration, as I mentioned, one of the elements which makes the contract legally binding. Terms we're going to look at, and then authorized persons. Again, do your due diligence in this area to make sure that whoever is signing or executing that contract does in fact have authority on behalf of the named party to bind that party into contract. It's something which is very easy to overlook or not to check. If in doubt, do ask the party for confirmation or for evidence that the person who is signing the contract with a beautiful signature has in fact got authority to bind that company. So those are the things to look out for when you're considering each component of the contract. Let's look at terms, because terms are important, as I mentioned. In legal terms, you've got three types of term. Each of those has a different impact. I'm going to set out all three of those now on the screen for you. We've got something called conditions. Conditions are the most significant parts of the contract. They go right to the heart of it. As such, you may not be surprised to hear that any breach of that term or any failure to comply with a term is classed as significant. It's given the legal terminology of repudiatory. Okay, if you have a condition which is breached and is repudiatory, that breach will entitle the other party, the innocent party, to terminate that contract and also to claim damages for any loss suffered. There's lots of different types of conditions. You need to look really at what the significance to the contract is of the condition. A little footnote there on conditions precedent. Conditions precedent is a type of condition. It precedes something else, so it must be complied with before something else can happen. Okay, non-compliance with a condition precedent means that that follow-on task cannot occur. Okay, it's a bit like having your logic links in your program. Okay, you must comply with a condition precedent before the next task or the next term in the contract can be triggered to take effect. The second type of term is a term called a warranty. It's not a collateral warranty, that's something entirely different. We're talking about contractual warranties. Contractual warranties are a term which has a promise in it. It's usually some kind of secondary assurance, so somebody is warranting that something is the case, or that they have so many people on site, or that the project bank account has been opened. It's that sort of term. Now, a breach of a warranty is not repudiatory. It is important and significant to the project, but it's not so significant that it goes right to the heart of what the contract is all about. And therefore, breach is not repudiatory. It does not entitle termination, but it does entitle the innocent party to claim damages for any loss which ensues. The term warranties includes undertakings and also indemnities. So we've got different types of warranties. Undertakings are promises which are legally binding without the need for another party to do anything. So I undertake to John that I will deliver a series of 3 webinars. Now, John doesn't need to do anything in order for me to do this. I'm committed to doing it, and I make that promise and I must comply with it. An indemnity is slightly different. An indemnity is a promise which doesn't need any proof of breach or proof of loss in order to trigger that right to damages. You have to watch out for indemnities because they have quite a far-reaching effect, and the other party doesn't need to prove its loss to you if there's an allegation of breach of indemnity. And then finally, the third type of contract term is slightly strange description, innominate terms. I like to call them ordinary terms. Basically, it's any contract term which is not a condition and not a warranty. The breach of an ordinary or an innominate term gives a remedy to the innocent party which is proportionate to the seriousness of the breach. And that is fair in the circumstances. The legal test, which you might be interested to know, is whether the innocent party has been deprived of substantially the whole of the benefit of that term. Okay, so there's quite a lot of information there. And in fact, it's pretty common to find workshops and seminars just on terms which can take half a day or so. But what I wanted to do was just to flag up to you that the really important part of the contract is these types of terms. Okay, you won't necessarily be able to identify which one is. So I'm going to give you some tips now to help you to try to identify which one is. So first off, as I said, cautionary note, do take advice on drafting, both drafting of the content of clauses, the words that you're using, but also on the categorization of clauses. Do they need to be, does a clause need to be a warranty, for example? Does it need to be a condition? Because the drafting needs to follow the categorization of the term. One way to do that is to ensure that the term has the effect that you want it to have. That's what we want to do. Statistically, and I've had a couple of these in my time, most terminations which fail, in other words, an alleged termination or an attempted termination which has been challenged and gone to court, and the court has said, no, this is not a proper termination. The reason for that statistically is because the basis for the attempted termination was insufficient. In other words, they got the category of the category and the content of the clause wrong. Following on from that, the court will take a few things into account, which are probably quite useful to know, because if you know what the court's going to take into account, you can do your drafting accordingly and try to get it right and nail it down. So in any dispute or in any attempted termination, the court will determine the type of term and also the evidence which is going to be required in order to satisfy it as to the content and the categorization. So the court will look at the face of the term. In other words, what does it say in the words? Does it say one party undertakes to do something? Aha, it's an undertaking. So you look at the face of the term. What does it say on its face? More importantly, you look at its intended purpose. Is it a term which goes to the heart of the contract? Is it some sort of secondary promise or an assurance item? Or is it just an ordinary term that helps the contract to move along? How central is the term to the contract? Again, that's the heart question. And there are also a number of statutory rules which have to be taken into account. Those provide constraints and limitations on certain types of terms, and the court will look at those as well. So those are all the sorts of factors which the court is going to look at when it's asked to rule on the term which is being challenged. So get your terms right and try to avoid those situations. Okay, let's have a look at something called boilerplate. Some of you will have heard that, and anybody who's been following on Twitter or through LinkedIn might have seen my few tweets over the weekend getting excited about this and inviting APM members to come and play SCL's Boilerplate Bingo. Trying to bring a little bit of fun and light to law, which can sometimes be difficult. But we're going to talk about boilerplate, and I've put that in speech marks because it is a legal terminology. Boilerplate means a series of terms which are usually found in a contract. Okay, straightforward. We're not talking, however, about the content of those terms, but we're talking about the subject matter. Okay, the content is in the detail of the stuff. So be careful with boilerplate, because if you give them a cursory glance, they probably look pretty familiar. Notwithstanding that, everybody drafts them slightly differently, so they are worth spending time to read. The point of boilerplate is to better define the parties' relationship. This goes a little bit towards how risk is balanced and allocated, and it is also to provide some standard terminology in terms of subject matter, which we ought to find in contracts. They do, boilerplate, however, change the underlying legal position. In other words, what the default position in law would be. We talked about implied terms in webinar 1, and this is a good point to cross-reference your notes on implied terms. So, like I said, I invited people over the weekend to come play Boilerplate Bingo, which is one of the things that we do in my workshops on contract law. I've got a sample on the next slide coming up, which you can use as a bit of a checklist. Like I said, it's an attempt to bring a little bit of light and fun to contracts. So here's my Boilerplate Bingo, and I invite you to use that as a sample of the types of terms which should be found as standard in your contracts. So you can tick them off as you find them whenever you're next looking at a contract. In the bottom right-hand box, you'll see in italics others. There are lots of others. I just wanted to give you a flavour by putting up 12 or 15 of the typical types of boilerplate clauses that you find in contracts. If anybody would like to play Boilerplate Bingo with me at any point in time, do get in touch. We run all sorts of really good fun workshops about contract law. Couple of points on boilerplate. What do you do if a boilerplate clause is missing in your contract? Well, you need to raise it up with the other party, and I would say suggest your own content and say, hey, we're missing this type of clause, here's one that we'd like to use. If you're working in an organization, then you probably need to check whether the organization has its own standard version, which it ought to. And if it doesn't, then now's your chance to shine and to suggest one of your own. What happens if you don't like the boilerplate that's been proposed to you? Well, again, flag it up and explain why you don't like it to the other party. And again, suggest your own standard version. The idea being to try to get as many of your own boilerplate clauses in as possible. Little footnote again, I'm making as much light as I can of boilerplate because it really is quite dull, but do take advice in these types of scenarios. The reason for that is really that any changes to boilerplate will affect the risk balance. They will affect how the parties are allocated risk as between themselves in the contract. It also may impact in other ways, and it might impact on other clauses. You do get clauses in certain contracts which are not cross-referenced to others, so you need to have a really good understanding of the whole of the contract because there might be impacts in other areas. There may also be, as we talked about in webinar 1, implied terms which will also affect the risk balance. So do take care when talking about boilerplate. But in the event that you have a boilerplate which is missing, or you have a boilerplate which you're not very happy with, there's a couple of suggestions there. And always tie it back into your organization's standard version if such a thing exists. Okay, let's move on to negotiated clauses. So we're not talking about boilerplate standard clauses anymore. We're talking about clauses which are in fact negotiated individually by the parties. A couple of tips here on how to approach those scenarios. Again, always start if you can with your organization's standard term, or have reference to some sort of policy if you haven't got a set of standard terms. One question to be very careful about is whether you have authority to negotiate the contract, or whether in fact you have authority to bind the contract. Do take care with the protocols that your organizations have. Perhaps there are some thresholds for certain post holders. I've certainly been in positions in-house where that's been the case. So do check on the authority point. There's also an interesting an interesting point to note in relation to negotiation. It's a real skill, and it can be very difficult and quite challenging. So if you get the chance to upskill in negotiation, go on some workshops. I thoroughly recommend that too. It will add enormously to your ability to project manage and to negotiate contracts. There is, of course, then, once negotiation has happened, the translation of what that negotiation is into words which are suitable for the contract. Agreed commercial positions is absolutely where we need to get to, but they do need to be worded appropriately, cross-referenced appropriately into the contract so that everybody understands what is what. Do take advice on nailing that bit of the drafting. A couple of reasons for that, primarily being that you want certainty and confidence in the contract. This is the contract, it underpins the whole project. And for you as project managers, that's going to give you exactly what you need. So I want you to have a contract which you feel confident in and which you have certainty about the rights and obligations and the performance that each party is to give. There's also a legal reason, if you like, to make sure that you get negotiated clauses drafted properly, and that is a legal rule called contra proferentum. It means against the proposer, and it's a rule which is often bandied about by commercial people because they believe that it means that anything that you say will be taken against you if you're proved to be wrong. That's not quite right, although there are a few grains of truth in that. What it really means is that if you propose a term to somebody and that it just doesn't work, okay, we're not talking about a term which is unfair, a term which is being challenged for being unfair. We're just talking about a term which doesn't read properly, which doesn't really work, where there's uncertainty about what the party is being asked to do. The court can apply this rule of contra proferentum, and it means it will be drafted against the proposer. It will be drafted to give an interpretation which is favourable to the person who did not propose the term. So that's another really important reason to get some help when you're drafting commercial positions into the contract terms. Okay, let's tie that all back into risk allocation. For me, risk allocation is all about the what if. A contract is an agreement essentially where the parties to that contract are sharing. In some way, they are sharing the risks of the venture, the objective, the project. Now that risk share might be 100% in one direction and 0% in the other, but nonetheless that is a share of risk. The terms of the contract then that we've been talking about will allocate the risk as between the parties. Okay, so we drill right down into who's going to take on which risk and why. As I mentioned before, some risks will be unacceptable to you, for example if they're against company policy. Some risks will be acceptable to you and fall within company norms. And some risks will start off as being unacceptable, and you'll flag them up when you review the proposed contract. But after discussion and negotiation, the parties will manage to get to some sort of a position which suits them both, which they can both comfortably live with. How you decide which category a risk falls into is all about the what if. And what is the organisational normal policy? Is there something which gives you that guidance to say this risk is or is not acceptable, or we can work with this one in principle? Can the risk be avoided? Can it be managed in some way? If we can't avoid it, then we have to manage it. And if we have to manage it, can we manage it ourselves, or do we need to get the cushion of insurance to manage it? Which party is actually best placed to do that? Which party is best placed to manage the risk? And have a think about also, if you flip that on its head, what's your exposure going to be if you take on a risk, but it isn't managed well, and it's not insured. I would just flag up at that point that insurance ties in very well with contracts. If anybody is interested in doing insurance and project workshops, just drop me a note or put a flag through the registration to me, and I'll pick that up. So risk allocation. It's really interesting, isn't it, that we have a number of industry standard forms of contract in all the different sectors that we deal with. My sector is primarily construction and engineering and some technology. So I deal with a lot of standard forms of contract, and they vary in their quality, in their length, and the words and the terms that are the content of them. Industry standard forms are supposed to set out the market acceptability of certain terms. They're supposed to set out where the particular sector is at. Now I put in question there, slightly cheeky maybe, or do they? You know, do they actually set out market acceptability? We're debating that all the time at different levels of industry, and I'm sure whichever sector and industry you are in as project manager, you're also talking about how your contracts or standard forms of contract that you come across actually are viewed within the market, and are they any good? So nonetheless, do start with a standard form. I find that the most helpful place to start. It gives a good grounding, a good foundation, and a great framework from which to start talking to the other party. Do take care with any special clauses which are added or suggested, or any additional clauses which change the standard terms. Ask that beautifully small but powerful word of why. Why do you want to put in special terms of contract? Why do you want to add additional clauses of contract? A few things to think about, of course. If you're starting with a standard form and you're adding a number of additional or special contracts, special clauses, those of course are going to change the risk balance of the contract. By change, by the way, I mean not only changing the standard form's existing words, so the words of the existing standard contract, but also adding new bespoke clauses and adding in any reference to the other party's standard terms. So there's lots of ways in which you can change standard forms of contract. Okay. However you do that, and whatever you do, those changes change the risk balance for the parties. And I always want to ask the question, what are you trying to achieve? Why do you want this clause in? What does it mean to you? Why is it important to you? Those are not churlish questions. Those are genuinely open questions as to why that party wants to change the standard form. Now, there may be very good reasons to do that. There may be some very bad reasons to do that, but it's a really important question to ask. Now, if you are faced with a whole bundle of additional or changed clauses, think very carefully about whether you want to enter into that contract at all. It's a slightly controversial view in a way, but it's an interesting and important step that I always make sure my clients go through. You think it's really important, you've got the job in, you want to do the work, you want to get on with the project, but take a step back and think about it from an organizational risk perspective. If you're starting with a standard form and you receive a whole bunch of clauses which are bigger and more complex than the standard form that you've started with, is that really the way that you want that relationship to be with the party that you're entering into contract with? What does that say about how that project is going to proceed? I'm not saying don't do it, I'm just saying don't jump the step. Do think about whether, in principle and in a philosophical sense for your organization, that's the right thing to do. There are some specific industry codes of practice which do need to be added in as additional and special clauses. So in principle, those would be acceptable. Of course, you need to check the precise wording to see how those are dealt with, see if they're properly reflected in the contract. So if we keep going with risk allocation for a little while, there's lots of different ways to allocate risk through the terms of the contract. Risk, of course, can sit outright with one party or the other, and you'll see the phrase one party X shall do such and such. Okay, so you're very clear as to that risk sits with party X. You can have risk which is jointly shared, which is genuinely jointly shared. Example wording, the parties together shall do such and such. Okay, so that's a joint risk which the parties have to do together and is shared jointly. There are other ways to share the risk too. So we can share risk in the outcome of something, and that is done or can be done by a number of different incentives. I've given the example on your screen of the NEC form of contract, options C and D, which are risk sharing forms of contract, and they have a pain gain mechanism where the risks in the outcome of the project, the cost of the project, are borne in different ways between the parties. Another way to share risk, which is a way I quite like to consider with clients on projects, is that one party takes the risk up to a certain level, and then the other party takes over the risk in over and above that level. So some example wording which I've made up is C shall issue a compensation event notice for any event listed in this clause, but if he does not do so within X weeks, he's time barred from pursuing it, unless the compensation event notice results from events 1 and 2, when he shall not. So in that, I have put the primary obligation onto C. C shall. You can see that right at the beginning of the phrase, of the term. Okay, and if he does not issue, if he does not do what he's supposed to, if he does not issue that notice within X weeks, he's time barred. Okay. Now, you could have a full stop there, and in many cases, in your amended NEC contract, you probably do see a full stop there. But one interesting development to extend that risk sharing is to add the words towards the end of it, unless the notice results from events, and you can put in your events there, when he shall not be time barred. So you're really sharing the risk at certain levels, and then pushing the onus and the risk onto the other party. Maybe something useful you could think about for your projects. However you allocate risk, it's really important to tie in the risk to the policies of the organisation, and also to the insurance position. That consideration piece can't really be done properly without reflection and cognizance of what the organisation's processes, policies and protocols are all about. Insurance, of course, you need to tie in to give you that cushion if you're going to be bearing the risk yourself. And then, of course, the risk eventuates, and you need to be able to deal with the consequences of that risk. At this point, I'm going to suggest that you take advice from a specialist risk manager. Now, you may well have those in your organisations to varying degrees. You'll certainly need to take technical advice on the subject matter of the risk. That's as a matter of course. You'll be drawing in and collaborating with all your colleagues in relation to the discipline risk. We're looking at probability of occurrence there, for example, as an item to talk to your colleagues about. And of course, it's incumbent on me to add as well to get some legal advice on the drafting. So again, getting the content of those terms and that risk allocation correct to avoid any scenario where the term might be challenged or might be deemed and drawn by a tribunal to be uncertain. So be careful with risk allocation drafting. Now, in relation to who should be involved, as you all know, I think by now, I am passionate about the project management profession and supporting it to do better, to deliver better projects in a more timely fashion. But I am often surprised about how little thought and time is given to contract negotiation, especially given how important it is. We've just spent the past half an hour talking about how you build a contract, what the structure of it is, how important those different types of terms are, how you might want to approach the risk sharing and risk allocation element of it. And then suddenly you're given a contract and asked to just have a quick look at it, and off you go. A good rule of thumb is to remember that the value of the contract is really neither here nor there, insofar as it's not necessarily an intrinsic indicator of risk or of potential liability. I have dealt with some relatively small value contracts which have had huge risks attached to them, and vice versa. Some very big contracts where it's been pretty easy work and great for the client with little risk attached. So don't necessarily equate contract value as this is an easy contract to just get on with. Equally, I would encourage and in fact beg you all to try to avoid giving your draft contracts to your lawyers at the last minute. It's happened time and time again, and I'm sure it will continue to happen, but quick looks at contracts are never really a terribly good job, and there's only so much you can do at the last minute when you're presented with a contract which has to be signed because the spade is going in the ground tomorrow. At that point you don't really have very much bargaining power and very much ability to change any of the words. So try, if you can, to at least flag up to your advisors that a contract is coming in, perhaps give them a previous draft so they can start looking for it and looking for any red flags that need to be raised before the 11th hour. I come back again and again to organisational protocols. We talked a little bit earlier about authority to bind. Of course, authority tends to come with seniority within the business. What's interesting and useful about seniority is that you also get that overall corporate visibility at a much higher level. So do make sure that you're involving the right people at the right level. Now, here is my assertion for project managers to get involved in contracts. I want you to include the key project people that are going to be in your team, okay? That's you and your delivery team leads. Why? Because everybody needs to know what is expected of them. It's very simple, really. There are certain obligations, i.e. terms of contract, which are going to have to be performed by different disciplines and functions within the organisation. And it's really important that each of those team leads understands how the proposed terms of contract are going to impact on the way that they do their job, the way that they deliver what they're being asked to deliver, the constraints that they have to work under, and perhaps there are different ways of working on this particular contract. So to me, it seems very simple, but it's amazing how often this is overlooked. And teams are just expected to get on with the contract. I would like to ask the question as to how you can give a contract to a team and then expect them to perform excellently. I really want to encourage you to have a voice within your organizations as project managers and to pull in the key people that you need. Because after all, you are expected to run the project. And how do you do it? Well, you have to do it according to the contract. What's the contract? Well, I need to see what the contract is in order to be able to work out how I'm going to manage this contract. So I want you to encourage the right people to contribute and also to make your own voice heard. It's so incredibly important that project managers have a voice and have visibility in contracts and in projects and in proposed negotiations. I'm not necessarily expecting you to be at every single meeting, at every single negotiation, but there are going to be points at which you think, hell, you know what? I'm the project manager on this. I really need to understand what this is all about because somebody is negotiating on my behalf. And that's in effect what people are doing. You're running the project once it starts. The framework for that project is the contract. Let's move on to how you project manage a contract development. So I like to think, and you probably won't be surprised to hear this, that contract negotiation, pre-contract negotiation phase is a project. I think it's a project because this phase is temporary. You're either going to get to a position where the contract is signed or not. You have a purpose to the phase. The idea is that you agree the terms of business as between the parties. Just like projects in general, there should be a strategic plan and a timetable attached to that contract negotiation phase. That, of course, needs to be linked to the underlying project. And that links into not just handing over a proposed contract to advisors or to somebody to have a quick look at the end. You need a proper strategic plan running up to contract signing. There's also a few things in contract negotiation phase which you need to achieve before you can move on to the next thing. We talked in webinar 1 about the risks of starting work before signing a contract. We also looked into the pros and cons of entering into a letter of intent, okay, if time is running short. So contract negotiation phase, in my world, is a project itself. And I strongly advocate that you, as the intended or the proposed project managers on that project, should be involved. You are, in my world, the face of the project and the driver of that delivery. And in developing that contract, during that contract negotiation phase, there are going to be some terms, some clauses of the contract which can be agreed quicker than others. It's quite, excuse me, it's quite pleasing to think that you've got some clauses agreed and that those can be crossed off the list. Others, of course, are more sticky. Just be careful with those ones not to do too many trade-offs. And actually to stay steady and to think in mind why that particular clause is important to you, why it is not acceptable, or why it is acceptable in principle, but there are certain elements of the clause which are not acceptable, and why. So don't just trade off tit for tat, commercial style. I'll take this clause if you take this one. That is not really going to get you into the right place for the contract. One way I've tried to approach particularly difficult contracts is to try to get the framework for that contract in place first, and that's to come at the contract from a principles first basis. In other words, to try and agree the very, very important philosophical skeleton of the contract, and then to try to fill in the detail step by step, sometimes quite tentatively, but always coming back to those principles. Keeping those principles in mind at every part of the negotiation. Do check back, and check back expressly to your other party as well. Say to them, look, we've been talking about this, but hey, these are the principles which we agreed for this contract. I'm not quite sure that they sit and they tie in together. And do take advice to make sure that that is consistent across the contract. I do very often come across contracts which are obviously patchworks. Sometimes that works, and it works to varying degrees, but it can be quite dangerous because the contract doesn't really tie together in a very cohesive way. Sometimes that's as a question of time, and sometimes skill, and sometimes a mixture of the two. But there are dangers to developing the contract in a patchwork fashion. Finally, I just wanted to mention something which is of interest to me, which I'm trying to develop some knowledge into, which interests me as a sort of a side learning piece. I've been doing some work in relation to machine learning and contracts, and how different types of artificial intelligence techniques, software, mechanisms, tools are encroaching into the area of contract development, contract negotiation. Now, there are quite a few techniques and tool sets out there which can do some of this work for you, and you will hear the hesitation in my voice. That doesn't come just from a place of being a lawyer who is fairly cautious about things, I'm a huge fan of technology. Those of you who know me already will know I'm quite a geek on technology and data, and the importance of using technology to enable and facilitate project delivery. And it is going to come. Machine learning is coming, and there are lots of different versions of artificial intelligence which are, as I say, encroaching in the area of contract negotiation. Now, they are fairly limited in their abilities at this stage. They're mostly used for a checking device. It's almost a comparison tool of proposed clauses against organizational norms. That's the area in which there is most traction right now. That's a pretty easy job to do. It saves quite a lot of time, when of course time is money, because it will flag up where a contract has clauses which don't really sit with your organization's standard terms. However, I would say very strongly, as for project managers in particular, that there is no real substitute for your brain. And the fact that you can contextualize the project and that you have the visibility of the whole of the project means that the importance of the things that we're learning is not going to go away anytime soon. Whatever software and AI is out there is not going to take over your abilities for a long, long time. I would also say that for me is another reason why it's really important for project managers to ensure that they do learn lots about contracts and get involved in a little bit of the basics of contract law. Whatever happens in the AI area is not going to change any of that. So those are my thoughts on how you can develop and project manage the development of a contract. I am looking at my clock and I have got 6 minutes left on it. I think I'm more or less at the end actually. So let's just do a quick summary. You will have heard me say throughout the past 50 minutes or so, do take care when building your contract or when you're reviewing a proposed contract from the other party. Remember that the terms of a contract relate to the allocation of risk. The boilerplate looks familiar but is not always the same. That negotiated clauses relate entirely to which party the risk sits with. And do take advice on the type of terms. Remember, we looked at those 3 different types of legal terms. Each has different impact and different consequences. Do get your voice heard. Do pitch into the conversation about the contract. I will say again, unashamedly, you are the project managers who are running that project. The foundation of that project is the contract. And as far as I'm concerned, that is all you should have to say to anybody who asks you why you're interested in the contract. Right, next time, webinar 3. Hope to see many of you there. What we're going to do next time is to look at what happens when things go wrong in contracts, or perhaps the unexpected happens in your contracts. Do join us. Please give me feedback. Does anybody have any questions?
Yes, they do, Sarah. First ones, we've got a number of questions around indemnities. What qualifies as an indemnity? Can you please give an example of an indemnity, please? And can you give an example of a breach of an indemnity?
Yeah, so an indemnity will probably say on its face, remember that's one of the tests that the court will use, this indemnity is, or such and such a party indemnifies the other against. And what that is that's a promise by the indemnifying party to do something for the other party. So I indemnify John against the costs of hosting this webinar if I am unable to attend it. John tells me it costs £1,000 to host this webinar and I have to pay him £1,000. John doesn't have to prove to me that he spent £1,000 hosting this webinar. He of course has to be honest, but he doesn't have to prove it. The law will make me pay that money irrespective of proof. Now, if I find out he's lying, I will countersue him and spank him. But that is how indemnities work. Okay. So they will say indemnities, they will have a clear promise on them, and you will have to strictly comply with the indemnity if it happens without proof and without requiring proof from another party. Very serious stuff, indemnities, so be super careful with them.
Okay, thank you, Sarah. Can I just, you don't have to do the next seminar on that basis. We have a couple of other ones. What's the difference between an agreement versus a contract?
An agreement versus a contract.
Can you give an example of an agreement?
Well, you can have agreements to agree, which is a bit like Colin Powell's unknown unknowns. A contract is only a contract if it has the components in it that we talked about in webinar 1. An agreement can be something else, and an agreement is often an agreement to agree, which is a terrible phrase, but what it means is that you don't have all the bits of the contract that you need, but you have some sort of relationship between you where you think something has been agreed between you. And an agreement to agree is like saying, I will do this for you if you're going to agree to do this for me, which is not the same as I'm going to do this for you and you are going to do this for me. Do you see? It's dependent on another thing happening, which is uncertain. Contracts don't like uncertainties. I don't like uncertainties, and I'm sure nobody else does in contracts. So to have contract certainty, you need those elements that we talked about in webinar 1, and you need to be clear about who is doing what and when, and to not leave anything open to chance. Even if it says something like within a reasonable time period, that is calculable, okay? But just leaving it directly open it is not going to give you the certainty that you need.
Okay, we've got time for one more question. It's a slightly embellished question. It was the question was, what's the difference between a term and a clause? I'll add to that. What's the difference between a term, a condition, and a clause?
Okay, well, a clause is a general word to describe different types of terms. There are 3 types of terms, the ones that we flagged up in the webinar just earlier. A condition is a specific type of a term. So we're doing sort of Venn diagrams here, aren't we? We've got conditions right at the bottom in the smallest circle, and then we've got terms, and then we've got clauses. Conditions have to fulfill that very significant, that heart of the contract. If you keep that phrase in mind, that's probably the best way of remembering what conditions are. Terms describes any of the sorts of terms that exist. Okay, so you need to be quite careful when you use the word terms, because of itself it's kind of meaningless. You need to be sure which type of term it is. Clauses, there is no legal difference between clauses and terms as far as I'm aware. They are fairly interchangeable. I would just say be consistent about which you're using in your contract, because if you're not consistent about it, you're going to give the suggestion to the reader that you do in fact want to make a difference between using one word or the other in certain scenarios. And you might want to do that. And if you do, then you need to make some good definitions. But if you don't, then be consistent about using one or the other.
Okay, right. Unfortunately, that's all the time we've got in terms of questions. Wow. There are quite a few. Sarah might well get back to you on some of them.
I will, if you leave your email address or your phone number, I'm happy to do that.
Or we can do it on the machine or something like that. Okay. So first of all, thank you very much, Sarah, for that. We've been getting some nice comments about saying thank you. Very useful, very clear, very plain English. Please do give us feedback on the forms which are sent out, so we can improve it and we can answer your specifics, etc. on the 3rd seminar, which is on the 24th of April, and as Sarah said, titled What to Do When Things Go Wrong or the Unexpected Happens. Couple of other seminars, not webinars, for your diary. The Northeast branch on the 21st of March have invited me to do a session called Incentivizing Your Provider, which is about positive incentives, because negative incentives, damages, etc., while necessary, have been shown to actually have negative effect on your project performance. So thank you very much for listening. Thank you, Sarah.
Thanks, everyone.